Any mention?
May it please your lordship. Your lordship, I beg to mention item number 4. Lordship, I'm praying for some accommodation. Learned senior counsel has some personal difficulty today, your lordship.
On premier by the petitioner, this is matter of the 3 weeks.
Much obliged.
May I please your lordship? Item number 6 of the hearing list, your lordship. This case is listed here on transfer from this other court, your lordship. So your lordship, due to some personal difficulty, I am seeking adjournment today on behalf of the petitioner, your lordship.
Yeah, for
the university, your lordship.
for the university. Union of India is a party here.
Yes, your lordship. And Union of India, R. Devnath is also there.
On premier by
Respondent number Nehu is 20.
on premier by the petitioner, this is matter of the 3 weeks.
Much obliged.
Lordship,
Item
there's
number
a
3.
joint request for item number 3, Lordship.
It's a joint request, Lordship.
I know.
After the puja vacation, we'll do
When
it.
will this matter be, over? Do you think we'll be able to do it within the end of this year?
Yes, my lord, surely.
On premier by the parties, this is matter after 3 weeks.
No obliged.
Lordship, I beg to mention item number 8.
My lord, item number 8, I have an objection because here the lady who has been convicted, my lord, is only for 3 years now, and almost 1 year she has already served the sentence. And I can show it from the records, my lord. The conviction is not sustainable in the eye of law, my lord, and unnecessarily incarcerating her for such a long period, my lord.
The allegation against her
366A.
is for abatement, but the main offence need to be decided. If the main offence goes away, my lord, then only the abatement fails. If the main offence is proved, my lord, then
363.
abatement question of
Charge-
abatement will follow, my lord.
I've been charged under section abatement and 366A, procuring of a child. The special court has found there's no case made up against me in abatement. Then how does that 366 survives? First of all, you have to have an abatement. So what my learned senior is saying is just the opposite. There is a finding that there's no abatement. Section 16 and 17 of the POCSO Act, they said, she very clearly said there's no evidence against me. Therefore, she has acquitted me on those 2 charges. Now, how did she convict me under section 366A? You have to have an intention. You have to have an intention that if I take the child, she is going to be sexually assaulted. That knowledge itself is absent. That convicting me under section 366A doesn't arise at all. So therefore, my lord, at least there's a conducting matter. Let me at least argue this matter, my lord. They can take after
What,
some.
my lord?
What is the connecting matter?
The 6, 8, 9, 10, 7, 8, 9,
There are 4
7, 8, 9,
persons
10, my lord.
convicted in this case, my lord.
Oh.
Sir Sulaiman also there.
Lordship, item 7, I'm there in item 7.
Yes.
Is the main appellant, your lordship. Is the one who has been.
So 7, 8, 9, 10,
7, 8, 9, 10, my lord.
same case.
Same case, my lord. Same case.
You're appearing in all.
No, I'm appearing in 8, 9, and 10, my lord.
8, 9, and 10.
8, 9, 10. But the others, we may argue later, but this 8, my lord, is little of urgency. My lord. It's a mother, my lord, lactating mother, was by the time she was convicted. So at least let me, my lord, I won't take much time, my lord. I won't take much time, my lord, in this.
But the main offence needs to be discussed, my lord. Thereafter, the question
Oh,
of
that of course, that'll be a matter of argument. That'll be a
we
matter-
cannot
you-
split
you
the
can
the
You can
trial was not split, my lord, for the appellant of Mr. Yobin. So here it will be difficult all the more, my lord. There may be that he has a merit, but it needs to be determined whether the main alleged offence has occurred or not. That will be the basic.
No, whoever alleged, the person whoever have committed any overt act,
No, we'll do one thing, Mr. Yobin.
my lord, my lord.
Okay, perhaps since he has asked for accommodation for the day,
My lord.
but we'll fix the date
My lord.
and no adjournment.
No adjournment, my lord.
In fact,
If that order is passed.
We can fix it on 6th.
6th of October, that is after the puja, my lord. Yes, my lord. 6, my lord. Yes, my lord.
All these matters will be taken up.
Yes, my lord.
Yes, Lordship, on 6, Lordship has fixed some other matter also.
Single or DB?
I think single, your Lordship. Single, your Lordship, some matter. Then come on 7.
Then 7.
7, my lord.
Then on 7.
7 October, my lord.
Even single, your Lordship.
Okay. So we'll take it up all the happy new take again. Revenue.
It's okay. I can do it.
Oh,
Then on 7, your Lordship.
7.
7. Apply, your Lordship.
Oh, that's okay.
Fine.
7, my lord.
7, 8, 9, 10.
Lordship, yes.
All together.
As agreed to by the parties, list this matter for hearing on 7th.
7th October.
It is made clear that no further adjournment will be allowed in this case.
Yes, my lord. My obliged.
Apply, your Lordship.
Cut to 7, 8, 9, 10. No?
Supplementary list, item number 1.
Wait, please, Your Lordship. This matter, Lordship, pertains to the verification of my degree certificate. Lordship, I was enrolled in the CMG University for the academic session 2011-2012 for B.Ed course, and I have cleared my B.Ed in the year 2012. Annexed 2, page 20 is my mark sheet. Lordship. And
we have, I think, similar cases in this court
Lordship.
with regard to this CMJ.
Yes, Your Lordship. My matter is only to the verification because respondent number 4 has verified my degree certificate, and after verification it was found to be fake. But the question is that, Lordship, when the university was dissolved by the Honorable Supreme Court in the month of February, how this verification officer in charge came into existence, Lordship? This is my only argument.
Matter has been, this writ has been admitted.
Lordship?
Has it been admitted?
No. This is the first.
You are appearing for?
Just for 1 and 2, Your Lordship, for the
You
state
have to take
respondent.
steps.
I have given notice to. Notice has already been issued by the respondent number 3 and 4, and I could not serve, Lordship. 4 and 5.
You take steps.
All right, Lordship.
But Mr. Edep was submitted that this petition has been filed. Where's the impugn order?
Impugn order is at page Lordship 56, page 66, 56, annex 10. Impugn verification letter, Lordship.
Kumnum Dogo? By the petitioner being aggrieved by a communication dated 11/6/2025 by the verification in charge CMJ University to the Directorate of Secondary Education Assam as far as verification of his Bachelor of Education as far as the verification of his degree of Bachelor of Education is concerned. The Learned Council has prayed that this petition may be admitted, and notice may be allowed to be issued upon the respondent 4 and 5.
3, 4, and 5, Your Lordship.
I have served. Notice has already been received by respondent number 3.
3,
Yes, Lordship.
4 and 5, comma, the respondents number 1 and 2 being duly represented by Ms. Leonard J, and notice on the respondent 3 have already been served. Have you filed your affidavit of service?
No, Your Lordship. No, Lordship. I have enclosed the notice which I have served to the respondent number 3, Lordship. I have enclosed the notice.
You inform the
Lordship, I'll do that.
Kumtuko. Last portion. On premium, the same is allowed. This petition is hereby admitted. Let notice be issued upon the said respondent 4 and 5. The same returnable within 2 weeks. This is the matter thereafter.
Lordship, interim prayer was there, Lordship, for staying the operation of the Lordship.
Let them.
Because Lordship, as a DP has already been initiated against me on the basis of this letter, Lordship. I'm working. I've been appointed assistant.
One thing, you see,
Lordship.
as far as stay is concerned, the other parties has to be heard. More particularly the respondent 3. But he's
Lordship,
not here
instead of maybe till a returnable date, till returnable date, Lordship.
Let it come.
Hello.
The list item number 1.
May please, Your Honor. Lordship, the records from lower court has come, Lordship. So I shall prepare the paper book, Lordship. 2 weeks time may be given, Lordship, after puja.
No objection, Your Lordship.
You
I'm
appearing
appearing
for?
for respondent number 3, P. Nongbre.
For 1 and 2, Your Lordship. That is the respondent.
How many respondents are there?
There are 3 respondents.
3. Ms. P. Procedural counsel for the appellant has submitted that the records, relevant records, as called for by this court by the order dated 11/9/2025 have since been received by the registry. It is prayed that some time may be allowed for the paper book to be prepared. The respondents 1 and 2 as well as the respondent 3 are duly represented by the respective counsel. Accordingly, as prayed for, this is matter of the 3 weeks.
Much obliged, Lordship.
Item number 2.
If that's your Lordship, Lordship, we need one more week to for paper book.
Your Lordship, as per the last order, the counsel for the petitioners had withdrawn themselves from the matter, Your Lordship. So notice had to be sent to the petitioners.
What's this matter about?
Your Lordship, it's an
export of all the export matter.
So export means why? What is the issue?
It's agreed by the restriction placed by the
Okay.
regulation on the movement of vehicles, Your Lordship.
But state University of Meghalaya. We have imposed some restrictions.
How are they affected?
It's because we have the government of Meghalaya has restricted the number of vehicles, Your Lordship. per day only 450 vehicles something, Lordship, they can move, Lordship. For that reason, they agree by that.
They agree by that?
Yes.
That is contingent to the situation?
Yes.
Yes, Your Lordship.
This is movement in the Docky Road.
Docky Road, Lordship.
But that is, even from newspaper we see time and again landslides are there.
Yes, Your Lordship.
So
For that reason, also,
it's hazardous for for transport and communication.
for the safety of all, Lordship.
But none appears for the petitioner. Mr. Leonard J. and Mr. Leonard Counsel appears for respondent. I take respondent so over. On premium by the Leonard Counsel for the respondent, list this matter up to 3 weeks.
Obliged, Your Lordship.
Item number 11.
My lord, this item number 11,
Order passed by the learned single judge, my lord. We have already filed the appeal, my lord. Just want to move.
What's the urgency?
My lord, there was a status quo order, my lord, that has been vacated yesterday. So that needs to be continued, my lord. That's why we have filed it. This is regarding appointment of doctors, my lord. Veterinary doctors.
Oh, but
Yes.
have you filed?
I have filed, my lord. Already filed, my lord.
If you have time, then it depends.
My lord.
Okay.
Lordship, I beg to mention item number 6 and 7, my lord. If my lord is please, if it can come up after 2 weeks, my lord.
No objection, Your Lordship.
On pre-made by Mr. S. and additional matters adjourned.
6 and 7.
This is here after 3 weeks. 2 and 3. Mr.
My lord,
2 and 3.
2, no, my lord. 6 and 7.
Or 6 and 7.
6 and 7.
8 is connected.
Is it connected?
8 is
Oh, hearing.
It is connected.
Yes, so 3 weeks.
Yes, my lord.
Milord, this is a matter of 2023, Milord, and I was my friend. Actually, I have not. I was not informed that it will be mentioned.
No,
The
6
connected.
and 7. 6 and 7. If you
9 it's over.
issue.
Mr. Chakraborty, I think it's their case.
It's connected. It's from the same.
Anyway, Milord, my one arises from the same judgment,
Oh, okay,
but it may be taken up. My one may be taken up. The light request. There is number,
But
no, number 9.
he has hearing been I mean, has this matter been heard?
No. This will be the first time. This will be the first time.
Even your case has not been heard.
No, not at all. All arising from the same judgment, the same case. Right.
Lordship, I beg to mention item number 12. Mr. P.K. Bora was there, my lord. Just received the paper book. He's not. I could not see him.
Which case?
Item number 12, Lordship. There was some mistake in the pagination, and now also he has given me a Xerox copy which is not legible, and he is not there, my lord. So I'm. After 2 weeks,
Okay.
I will try to inform him, my lord.
Please. On pre-made by Mr. Tukajohi, this is matter after 3 weeks.
Highly obliged, my lord.
May I please, Your Lordship? Item 14, my lord. My lord, kindly, my lord, adjourn this matter, my lord.
You're for?
I'm for the appellant, my lord. My lord, kindly have after 3 weeks, my lord. And my lord,
Yes, Mr.
Lordship, the corporation, the MECL is the main contesting party, Your Lordship. So far as state is concerned, I would have no objection.
But have you informed?
But I inform Mr. Akin, AG sir is appearing in this matter for the MECL.
Oh, MCL.
Yes, my lord. My lord, the interim order may continue, my lord.
Is there any?
My lord, yes, my lord.
On pre-made by the appellant, by Mr. Letter Counsel for the appellant, that is adjourned. List is here after 3 weeks.
Okay.
As prayed for, the interim order, the interim relief ordered by this court, by order dated interim relief as ordered on when?
My lord, the extended, my lord, the order date on 10/9/2025. Order was extended, my lord.
Okay, we'll phrase this.
My.
You can't say the date. The interim order, if any, will continue until for the orders.
My lord. Highly obliged.
Please, Your Lordships. Lordships, I beg to make a mention of item 8. It's a joint request, Lordships, to have this matter after puja vacations.
No, this one.
On pre-made by the parties, this is matter after 3 weeks.
Highly obliged, Lordships. Lordships, a similar prayer for item sorry, Lordships. Item 16.
Have you informed the other side?
Yes.
We are for the respondent number 2 and 3, my lord.
You are the main respondent?
Yes. Of the two issues, one is no longer survive. Anyway, my colleague is taking some time.
2 weeks means we are already in the holidays. So it will go after 3 weeks only. On premium of the appellant, not objected to by respondent 2 and 3. That is adjourned. This is after 3 weeks.
Highly obliged, Lordships.
May I please, Your Lordship, I beg to mention item number 13, Lordship. Due to personal difficulties, Lordship.
May I please, Your Lordship?
We appeal on behalf of the state respondent, Your Lordship.
This,
Privately.
I have wondered, this P.T. Shangma was very much here, so now we are at the time of hearing.
No, Lordship. Due to personal difficulties, Lordship.
What is this case about, Mr. Ajirga?
I don't know, here, my lord.
VC, Your Lordship.
VC.
Oh, VC.
Yes, my lord. They have
They have
dissolved the VSC for on the basis of the photostat copy of the resignation letter by the BDO. Somebody has submitted that one. Yes.
So next date.
And all these, actually, they had filed a writ petition by suppression of facts, which is why the writ petition was dismissed, Your Lordship.
You are for respondent?
Private respondent.
Number?
4 to 6, my lord.
On preempted by Mr. There are counsel for respondent 456. Not objected to by Mr. A.H. Hajarika. There are counsel for the appellant. Matter is adjourned. This is of the 3 weeks.
Just after puja, my lord, because VSC matter.
It will come in due course.
Okay.
Yes.
Your Lordships, I beg to mention item number 9.
No, I'm sorry, but matter is 2023, huh?
24.
When do you? Who is there? I was fully prepared to do that matter.
Connected with those.
It's connected with it, but
Mr. Chakraborty, what you can do is, even if you start today, let's suppose you start today, they will still need time to argue to respond in the absence of the
Well, the only problem is that we find it very difficult to show our face to our client, Milan. If it continues and ends up in a rejection of our prayer, we don't mind, Milan. But Milan, after taking of the brief, that is the sad part. That is the only thing.
True, I understand, but it depends on the convener of the parties also.
My lord.
Otherwise, like I said, we can allow you to start. There's no harm.
But it's the same thing, because
it will not be completed in one day.
There's no, it won't. No, it will not be completed also. Okay. But in the absence of my friend, it's not very just for me to do also, because after all, she is not the arguing counsel. Arguing counsel, in the absence of the arguing counsel to do also, for me, on my part also, I don't feel good about that. Anyway, let me, since they can't do it today, what is?
We'll fix it with those the other case.
Well,
on pre-made by Mr. Leonard J. Seeking accommodation. This is not being objected to by Mr. S. Kavarti, Leonard Counsel for the Appellant, Senior Counsel for the Appellant. That is adjourned. This is after 3 weeks.
Obliged. Daily list item number 1.
Last time. Okay.
May I please, Your Lordship? Let this matter must become after holiday, Lordship. Due to personal difficulties, conducting counsel is not here, Lordship.
Yes, who's there? Mr.
I'm for 1 to 4, Your Lordship.
On pre-made by Mr. Then Counsel for the Appellant seeking accommodation on ground of personal difficulty. Matter is adjourned. This is after 3 weeks.
Item number 2.
My lords,
May it please your lordships. Lordships, I'm appearing on behalf of Mrs. R. Datta, Lordship Learned Legal Aid Counsel. Lordship, I'm praying for some more time, Lordship, to file a reply to the objection that we had filed. The respondent number 1 had filed to our application for grant of special leave to appeal.
Oh, that is.
I filed an objection, my lord. First, I'm challenging the locus. The person who is seeking to file this appeal leave is neither a complainant nor a victim. It's a relative. It's not like a civil court where the legal heir can be substituted. So this is right to appeal is not inherent. It's a creation of a statute. So once a statute does not allow, then you have no right. So that's the objection that I'm raising.
Also,
my lord, this is a murder 302. Yes. I was acquitted, my lord. So anyway, my lord, if they're seeking
murder case, who is the victim is already deceased.
The victim is already this is the complainant. The complainant is the law says the complainant can file an appeal. Has a right to file an appeal.
Or the state.
Yes, or the state. Here, legal heir of
the person who comes within the definition of complaint, the victim.
Yes.
Victim died doesn't mean that victim disappears. The next kill to the victim, victim's husband, victim's brother, sister, will come under the category of victim.
Lordships.
That is where it is to be seen.
Yes.
You have to see the relationship.
Yes. But then, there's an arguable case, my lord.
What is the relationship?
Lordships, I'm the sister of the deceased. Lordship.
So,
Lordship may grant me some more time, Lordship, to file a reply.
2 weeks.
2 weeks after vacations, my lord. Yes.
After vacations. On premise by Miss Counsel for
the decision of the tax court with regard to victim. Just see.
Lordships.
My lord, yes.
Of course, that.
Yes. Section 2, CRPC, my lord, that victim.
It is elaborated and explained.
Yes, my lord. Yes. All right.
Applicant norm names. Kununto. Seeking accommodation on grounds of personal difficulty, matters adjourned. This is after vacation.
All right.
Item number 4.
May I please, Your Honor?
Yes.
Your Lordship, the conducting counsel was here, but due to some urgent work, he had to leave. Just now he left, Your Honor. So kindly the matter may come up after the puja vacations.
Or pre-made by Mr. Learned Counsel for the applicant, seeking accommodation on the ground of personal difficulty of the Learned Conducting Counsel, Mr. K.C. Gautam. Matter is adjourned. Please see him after vacation.
Okay. Lordship.
Item number 10.
May I please, Your Lordship? Your Lordship, in this matter, I seek for some additional time, Your Lordship, to prepare my hearing on the appeal, Your Lordship. However, Your Lordship, I pray that Your Lordship may be pleased to hear the misapplication for suspension of my sentence, Your Lordship. Your Lordship, on the last occasion, on the last date, Your Lordship, we have filed an affidavit to bring on record the medical report of the convict, Your Lordship. The convict here in this case is suffering from serious medical ailments and which requires surgery, Your Lordship. Your Lordship, the medical facilities available within the prisons, Your Lordship, is not adequate to manage his condition, Your Lordship.
So you are not prepared to be heard in the matter today?
On the main appeal, Your Lordship. But for the missed case, Your Lordship, I pray that Your Lordship may hear this, the missed case, Your Lordship, to suspend his sentence, to allow him to undergo medical treatment, Your Lordship, to have his surgery in a proper hospital, Your Lordship.
What is the case of POCSO?
Yes, Your Lordship.
How many years?
It's for 10 years. He was convicted on 19/1/2023, Your Lordship. The missed case is missed case 92 of 2024, Your Lordship. Your Lordship, on 17/9/2025, we have filed an affidavit to bring on records the medical report of the accused, Your Lordship, of the convict, Your Lordship. Your Lordship, since Your Lordship, due to the urgency of the medical condition of the convict, we were unable to seek leave of this honorable court to file the affidavit, Your Lordship. So we have filed this affidavit, Your Lordship, to bring on record, solely to bring to the notice of this court, Your Lordship, the medical condition of the convict, Your Lordship.
What is the opinion of the doctor?
In page 10, Your Lordship, and the type copy is in page 12. He referred for surgery, Your Lordship. The convict was taken to the hospital on 7/7/2025, Your Lordship. Thereafter, numerous tests was conducted, and on 24/7, he was referred for surgery. Thereafter, several tests again was conducted, and as per the report, the latest report, Your Lordship, it is in page 20. 24, Your Lordship. The accused is suffering from calculus with upstream grade 2 hydroteronophysis. Thereafter, also, Lordship, since 7/7/2025 till date, Your Lordship, only tests were being conducted, Your Lordship.
Where's the recommendation? What is to be
For
done?
surgery, it's in page 12 of the affidavit, Your Lordship. Type. Page 10 is the original, Your Lordship, with type copy, without the type copy. Refer for G surgery IVU grade 2 HDUN.
This one.
Your Lordship, this is a serious kidney problem, Your Lordship.
As far as the medical terms are concerned, we may not understand.
We are not familiar with these terms. But this
to what
report
extent
was given in July, Your Lordship, and this matter had come out on several occasions, Your Lordship. So we may call for a report from medical report, Your Lordship.
If the ailment is really serious, he was recommended for
Surgery, that it should have been
not being done till date, then it might cause more harm than.
Yes, that is also there. Therefore, Your Lordship, I just, because this report for surgery, recommendation for surgery was given in July, Your Lordship. This matter had come up on several occasions before Your Lordships, but no such prayer was made for a suspension of the sentence to allow them to go for medical treatment. Now, Your Lordship, this is very difficult to understand, but it appears that he's got some stones in the kidney. Nonetheless, Your Lordship, I would pray that a report may be called from the superintendent of the jail, Your Lordship, just to confirm what is his position, and then
Yes, we have to, because you see, what we have to understand is this: if his ailment is such that it can be treated through the agency of the medical team in the prison,
yes, Your Lordship,
or
or he needs treatment.
That he needs to be admitted in any hospital. Nigrims, you have gone to Nigrims.
Nigrims,
and to be his surgery to be done there. Then question of bail will not come, because you will be under proper medical care.
Attention, as well as but once suspended, then Your Lordship.
But if he is recommended that he needs specialized treatment outside. Suppose, for example,
all the other report, everything else seems to be okay, Your Lordship, except for the stone. From the report, what we can understand, Your Lordship, what little we can understand. Everything is normal.
Because we don't understand.
But yes, except for the stone in the kidney, Your Lordship.
Your Lordship, there has been so much of delay, Your Lordship. From 7/7, he was taken to Nigrims, but only tests were being conducted, Your Lordship.
But why? When the recommendation is for surgery?
For surgery, again, some more tests were being conducted from date to date, Your Lordship. And the last test was on August 28th. And in the last prescription also he was advised for some more tests, Your Lordship.
That can be done.
Yes, Your Lordship.
Even when he is in custody, it can be done. He can go for. See,
Yes, Your Lordship.
there's no stopping him to be tested.
Yes, Your Lordship,
But why would you see? You have to
the delay
understand.
may cause may
Why
affect
would it requires sentence
to be suspended?
You have to convince us. If everything fails, then. But as far as we are concerned, we may not understand the legal, the medical implication. What we can understand is this: that if he is been taken care of, he has been taken to Negrims for that matter to be tested from time to time, and Negrims may have. See, we cannot say or we cannot dictate terms to the doctor to say that no, he requires surgery, let it be done immediately. That's for them to say. If even at this point of time, in August or
September, end of September, Your Lordship.
Whatever the case, if they still, have not, what should I say, emphatically says that he requires surgery,
urgent
surgery, then what we can't do anything about it. What we can do is we'll
call for a report.
Call for a report. But we will give a direction that if urgency requires that he is to be
taken for surgery immediately,
then they'll do it.
That should be there, Your Lordship, to be fair.
Yes. The only thing is that because you see, this court is not averse to the treatment even outside. That is not if he is to be taken care of outside for better facilities, whatever. But if we have adequate facility here, and as my brother was just remarking, we don't know the nature of the ailment, whether it's serious or not so serious or very serious, we don't know. Anyway, I took a main case. I took a main appeal on pre-made by Mr. Letter Counsel of the Appellant. Matter is adjourned. List the same after 3 weeks. Took a miss case no more. I missed Letter Counsel for the applicant convict or appellant has submitted that this application has been filed with a prayer to suspend this sentence of the appellant on the ground that he is required to undergo proper medical treatment since he is ailing for quite some time and has been treated at many only in Negrims and has been treated at Negrims, for which the opinion of the doctor where's that page?
It's in page 10.
Well, doctor dated 24/7.
Yes, Your Lordship.
24/7/2025 is a reference for general surgery to be undergone by the appellant. However, since then, he has been made to, he has been visiting the Negrims from time to time, and only several tests have been conducted. It is the submission of the letter counsel that the ailments of the appellant is serious, and as such, if the sentence is suspended and bail is granted, he will he and his family members will avail of the necessary treatment, even from medical institution located outside the state. Mr. Tiangi Larat AG, appearing for the state, responded. On the other hand, though admitting that the appellant is indeed suffering from certain ailments, as has been indicated, as was found from the many reports, medical report filed by way of an affidavit by the appellant. However, as to the severity of the ailment, it is not known till date.
Because at page 8, Your Lordship, if I may interrupt, everything is normal except for the stone.
Since one of the report would indicate that everything is normal except for the presence of stone in
the ultrasound report, Your Lordship.
Stone in the gallbladder or kidney?
So kidney, Your Lordship.
Kidneys. However, the learned AG would further submit that the jail authorities, through the medical officer, will be allowed to file a report on the condition of the medical condition of the appellant, and to also advise as to whether he is required to be treated in any private medical facility. We have considered the submission made, and we have also gone through the relevant through the papers furnished through the said affidavit. There is no definite diagnosis of the condition of the appellant, except for the said recommendation dated 24/7/2025. This being the case, as submitted by the learned AG, we hereby call for a detailed medical report from the prison authorities, who will file such report on examination of the appellant, and the matter will be further considered when the said report is produced to this court. In the meantime, in the intervening period, if the condition of the appellant do require urgent treatment, such as surgery, etc., it is open to the prison authorities to take steps immediately in this regard, and the relatives of the appellant to be informed accordingly. I think that much.
With intimation to the court, no. With intimation to the court.
Not necessarily, because they will do it if it's an emergency, requirement. Maybe at midnight is required. You can't intimate a court. What we have called for is for the relevant report to be filed on a certain date, and then we'll see. This matter on 6 October.
6th, I may not be there, Lordship. 7th or 8th is okay, Lordship.
8th.
Okay, Lordship.
How do you apply? I'm not sure. Item number 11.
On pre-made with parties, this is matter after vacation.
Much obliged.
Item number 15.
That is not okay. He has not gone through the form. Doesn't know that. Yes.
May it please the Lordship. Lordship, this matter pertains to dismissal from service, Your Lordship. Lordship, if I may place my case. Lordship, the brief fact of the case is...
You are for the?
Respondent.
Who's for the appellant?
AP Kharsar, no, Your Lordship.
No, not here.
Not sure, Your Lordship.
None appears for the appellant. One prayer made by Ms. K. Gurung, direct counsel for the respondent. That is adjourned. This is now after 3 weeks.
Thank you much, Lordship. From supplementary 1, item number 1.
Lord, this is an appeal against the order dated 25/9/2025, by which learned single judge has.
Any caveat?
My Lord.
Any caveat?
No.
Well, it's being served. We are waiting for the respondents. All the respondents.
All the respondents are here.
Yes, my Lord. So, my Lord, this is against the order dated 25/9/2025, passed in WPC number 394 of 2025, by which, my Lord, the earlier status quo order was not continued. So we are aggrieved by that order. Therefore, my Lord, we have challenged. So before, my Lord, I come to the impugn order, I would like to, my Lord, give a background of the case, my Lord. Now, if my Lord will see the writ petitions which has been enclosed as Annexure 1, my Lord, page number 20 onwards. Now, my Lord, this writ, the appellant herein, my Lord, if my Lord will just come to page number 23, my Lord will see the synopsis. Page number 23 onwards, my Lord. Now, the writ petitioners herein, my Lord, they are the doctor, veterinary doctor, my Lord. They were working in the department of the government of Meghalaya, that is Animal Husbandry and Veterinary Department, my Lord, as a animal husbandry and veterinary officers. They were initially appointed on contractual basis and they were serving, my Lord. After their term period was initially over, their services were extended and some of them are still working, some of them their term has just expired.
So, term in what sense?
Because they were under contractual basis, so the extension from time to time, my Lord. Some of them are still working and some...
Okay, tell me,
yes,
is 3F still prevalent?
3F, my Lord, still it is there, my Lord.
Okay.
It is there. Now, my case here is, my Lord, not regarding my past appointment. That is my only background. I was working in the same department, my Lord. Now, the MPSC, my Lord, they floated an advertisement on 26th May 2025, my Lord. That is at page number 63.
Yes.
The serial number 1, my Lord, in the table, my Lord will see Animal Husbandry and Veterinary Officer under Animal Husbandry and Veterinary Department. Total number of posts is 51. Now, if my Lord will come to the same advertisement, page number 67, my Lord. Same advertisement, page number 67. Now here, paragraph 6.1. It says, for post of Animal Husbandry and Veterinary Officer under the Animal Husbandry and Veterinary Department, The Commission will adopt recruitment through direct interview as informed by department wide letter number so and so, so and so. Now what had happened is, my lord, the appellant herein, my lord, who were the writ petitioners in that earlier proceeding, my lord, because they were already working under the contractual basis, so my lord, the department wanted to retain their service. So they also wrote a letter to the government also that the vacancies which are there, around 8 number of vacancies, should be filled in from amongst these appellants only. That letter is also there, my lord, that is at page number 75, my lord. I'll just read, my lord. It says, with reference to the above cited subject, I am to forward herewith the appeal received from the grievance candidate who appeared for the MPSC interview that were not recommended by the Commission. As per the result declared by the MPSC, 51 candidates have been recommended in accordance with the number of posts advertised. In this regard, it may be noted that the anticipated vacancy up to December 2025 are 6, and in addition 2 clear vacancies arising from the recent retirement of officers, bringing the total number of vacancies to 8. The above mentioned posts are reserved for the animal husbandry and veterinary officers who are currently on deputation to Community and Rural Development Department and Wildlife and Forest Department. The officers on deputations may be reverted back to the department as and when vacancies arise. In the light of the above, the Directorate requests that these 8 vacant posts may kindly be filled from amongst the grievance candidates as per the list enclosed. The Directorate will ensure that all future advertisements are published in accordance with the established roster system. Now, even the request was made from the department that you fill up these 8 vacancies at least from amongst these candidates. Now, what has happened is, my lord, and therefore, my lord, department has also written to the MPSC that as far as these people are concerned, because they wanted their services to be regularized, so they were in belief that their services will be regularized through interview. As it is held by MPSC, special interview, the services are regularized. That was the my lord, understanding which the petitioner also had. And when the advertisement was floated, my lord, petitioner having the requisite qualification has applied for the post, my lord, and my lord, none of the petitioners, my lord, who are also toppers, as well as some gold medalists also are there among the writ appellant, my lord. None of them could qualify. And my lord, the advertisement spoke about only through personal interview. Now, only through personal interview entire recruitment process was done. Now, there is cantina of decisions, my lord, of the Honorable Supreme Court. The only personal interview cannot be the basis for selection, my lord, because it leads to manipulations and many other things, my lord. Now, if my lord will see the service rule, my lord, second page, my lord, I have tagged it, how the recruitment has to be done in terms of the service rule. Service rule, that is called Meghalaya Animal Husbandry and Veterinary Service Rule 2000. My lord, may kindly come to rule number 7, second page only, my lord. 7, method of recruitment. Now, rule 7 clause 5, my lord. Rule 7 clause 5 provides how these posts, animal husbandry and veterinary officers, which are grade 2 post, grade 2 junior post, how this can be filled in, my lord. Rule 7 clause 5, it says, my lord, appointment to any post in grade 2 junior shall be made by direct recruitment on the result of the examination, interview conducted by the commission. Now, if my lord will come to rule 11, that is second page, my lord, rule 11, yes. Next page, direct recruitment. Now, if we go through, my lord, we will understand how the recruitment has to be done, my lord. Rule 11 clause 1 says, examinations, interview for direct recruitment under sub-rule 5 of rule 7 shall be held at such interval as the appointing authority may, in consultation with the commission, from time to time determine. the date on which and the place at which examination shall be held fixed by the Commission. The examination shall be conducted by the Commission in accordance with the syllabus as the appointing authority may from time to time make in consultation with the Commission. 3. Of the number of vacancies to be filled up on the result of each examination, there shall be reservation in favor of candidates belonging to scheduled castes, scheduled tribes to the extent and subject to the conditions as the government may from time to time prescribe. On the basis of the result of the examination, the Commission shall prepare a list of all successful candidates in order of merit, which shall be determined in accordance with the aggregate marks obtained by each candidate. It talks about aggregate marks, aggregate of both examinations as well as interview, my lord. Aggregate marks obtained by each candidate, and if 2 or more candidates obtain equal marks, the Commission shall arrange them in order of their relative merit, which shall be determined in accordance with the general suitability of the candidates for appointment to the post. The number of persons to be included in the list shall be according to the actual vacancies that are likely to occur during the recruitment year plus 10% of the actual vacancies, or 2 names which is less, the list shall be forwarded to the appointing authority. Then the 5 is, my lord, it says the inclusion of candidate's name in the list confer no right to appointment unless the governor is satisfied after such inquiry as may be considered necessary that a candidate is suitable in all respect for appointment to the post, and that appointment to post in service is subject to availability of vacancy. Now, the rule clearly says that when you fill in this post, my lord, of animal husbandry and veterinary officer, that has to be by direct recruitment, and direct recruitment is mentioned in Rule 11 how the procedure has to be followed and how the marks has to be calculated. It has to be aggregate marks. Aggregate means both examinations, written examinations and interview. Now, my lord, the next tag I have put in my service rule, my lord. Now, the last column here, it says grade 2 junior animal husbandry and veterinary officer by direct recruitment. These can be filled in by direct recruitment only, and when it comes to direct recruitment, procedure is mentioned under Rule 11. Now, in spite of the fact that rule is so much clear, which has been pointed out before the learned single judge at the time when the matter was mentioned, moved on the initial day, first day, my lord, and the learned single judge being satisfied with the submissions and after going through the rule, my lord, has granted a status quo order. That is at page number 91, my lord. It says, my lord, heard Mr. Sincon, learned counsel for the petitioner, so and so, my lord. The third paragraph, the grievance of the writ petitioner is with regard to the conduct of a direct interview for filling up the post of animal husbandry and veterinary officer under Animal Husbandry and Veterinary Department. Mr. Sincon, learned counsel for the petitioner, submits that the advertisement and the selection by the Commission is in direct contravention of the Meghalaya Animal Husbandry and Veterinary Service Rule 2000, wherein at Rule 7.5 it is given that the appointment to any post in grade 2 junior shall be made by direct recruitment on the result of examination interview conducted by the Commission. He further submits that the method adopted by the Meghalaya Service Commissions has resulted in nepotism, and through the writ petitioners, though the writ petitioners are eminently qualified, their names did not appear in the select list. He prays that interim orders be passed in order to protect the interests of the writ petitioners. So and so, learned AZ for the respondent number 1 and 2, so and so, learned counsel for the respondent number 3 prays for allowed 2 days time to obtain necessary instruction, list the matter on so and so for consideration of the interim prayer till the next date. However, status quo will be maintained. The court has granted the status quo order. However, when the matter was listed on 25/9/2025, the counsel, the senior counsel from the respondent side, my lord, they have made their submission that is recorded in page number 93. I'll just read the order dated, impugn order dated 25/9/2025, my lord. It says, my lord, the relevant persons only, my lord, I'll read. Learned counsel appearing for the respondent number 3 have appraised this court that the rules as they stand allow for appointment in direct recruitment to be made either by direct examination / interview, and as such conduct of the selection by interview is not violative of the rules as placed. It is further submitted that the advertisement has also clearly indicated the fact that the same was to be by interview, and the petitioner at that point had never put a challenge to the advertisement. As such, it is submitted that the petitioners are stopped at this stage from raising these objections. Be that as it may, let an affidavit be filed by the respondent by the next date. The status quo order passed earlier shall not continue. In spite of all the submissions made, not even single line has been recorded, which has been submitted by the counsel for the petitioner, my lord. Not even single line, and without giving any reason, my lord, the learned single has not continued with the status quo order. What I find, my lord, the order should be with a reason. Even if, my lord, the order has to be vacated, that has to be by a reason, my lord. There was no reasoning that has been provided in the order, and moreover, my lord, I was surprised with the submissions on behalf of the state as well as, my lord, on behalf of MPSC, that they have taken a stand that it can be either by a direct examinations or interview, my lord. Now, the MPSC, my lord, of their own, they have issued an order, my lord, that is at page number 80. My lord, may kindly see page number 80 of the petition, my lord.
Yes.
My lord, it says the Meghalaya Public Service Commission has, after reviewing the selection process to the various posts advertised, has decided to make written examination / screening test mandatory in all the process of recruitment / selection for all types of posts that will be advertised by MPSC. Henceforth, irrespective of the number of applicants, the practice of conducting of interview only without a screening test written examinations has brought negative response from applicants across the state, and thus the decision to put an end to this practice. There will be no more recruitment with personal interview only at all entry-level posts in all government department of the state conducted by the Meghalaya Public Service Commission. The recruitment / selection will be made strictly on merit basis through an initial written examination screening test phase, which will be followed by personal interview phase. Subsequently, the skill test or physical test, being different from interview, may continue as usual. However, this test will only be of qualifying nature. The decision to discontinue the process of direct interview only for all level posts in Meghalaya Public Service Commission will act as a major step towards achieving the objective of citizen-centric, transparent governance. Now, same MPSC, my lord, comes before the court in this particular case, gives a different submission, my lord, altogether. Now, even, my lord, Honorable Supreme Court, my lord, in earlier occasions, my lord, while deciding other cases, my lord, has held, if my lord will see, come to page number 15 of my petition, my lord. Paragraph number 5.8, my lord.
Yes.
I have referred a judgment of the Honorable Supreme Court, my lord. It says, Praveen Singh versus State of Punjab and others, my lord, wherein, my lord, at paragraph 9 it was held, what does Khulsetra case so-and-so direct? Does it say that an interview should be the only method of assessment of the merit of the candidate? The answer obviously cannot be in affirmative. The vice of manipulations, we are afraid, cannot be ruled out. Though the interview undoubtedly is a significant factor in the matter of appointment, it plays a strategic role, but it also allows creeping in a lacuna rendering the appointment illegitimate. Obviously, it is an important factor, but ought not to be the sole guiding factor, since reliance thereon only may lead to sabotage of the purity of the proceedings, my lord. Now, my lord, it is a settled position of law that the recruitment process, my lord, if it is conducted by only a personal interview, there is every possibility that it will be full of manipulations, and it will not be a fair procedure, my lord. Now, as far as state is concerned, my lord, state is duty bound that in matters of public employment, which is a fundamental rights, my lord, under Article 14, 16, my lord, 21, they have to maintain fairness, transparency as far as recruitment process is concerned. Now, what has happened in this case, my lord? The board which conducted the interview, my lord, they were using pencil, and the kind of questions, my lord, which they have asked, that is, my lord, may kindly see. Some of the questions, my lord, we have just put in for the record of the court, my lord. Page number 24. They have asked so many irrelevant questions which has got no business with the present case, my lord. Now, they have asked what is the pin code of Khanapara, who is the king of rock and roll, what is the motto of their school, my lord. These are the questions, my lord. When is the cherry blossom festival is held, my lord?
You cannot go to that extent.
My lord,
why you are arguing all those things?
My lord, these are only now. Only my question is, my lord.
Are you trying to impute biasness?
But definitely, my lord. I am. That is exactly what I meant to say, my lord. This is not a fair procedure which has been adopted by the MPSC, my lord, and also the state, my lord, and therefore the status quo order, my lord, which was earlier granted, after satisfying that the rule prescribes about the examination as well as interview, which talks about aggregate marks. In spite of all that, my lord, after pointing out all those, my lord, the honorable learned single judge, my lord, has not continued with the status quo order. Being agreed, my lord, we have filed this writ appeal, my lord, challenging the order of the learned. I want, my lord, the
main petition not yet.
My lord, that is yet to be there. They are yet to file the affidavit, my lord, in those cases. For the time being, I just want protection, my lord, that the post, my lord, that may not be filled in, my lord. Because once those vacancies are filled in, my lord, there will be nothing left for the petitioners, my lord. They are all doctors with equivalent qualifications, my lord.
Where is the advertisement again?
Advertisement is page number 63, my lord.
Dated 26 May.
Yes, my lord.
This expires on 27th June.
27th June was the last date of filing the applications. Yes. Lordship. 1 month time.
Now,
was there.
result has been
Here
already declared. That is
written that it would be examination slash interview.
Just
it is slash interview.
Page number
Lordship.
70, my lord.
Not examination and interview.
Just a moment. This is the interview.
Yes.
Brought out.
My lord, page number.
You are also eligible to apply.
I have already participated, my lord. Result was declared. That is at page number 70, my lord.
Okay, you have participated.
I have participated, my lord. But my lord, law says, my lord, there is no estoppel against the law. Now here, my lord, when it is totally against the rule, there cannot be estoppel as far as petitioners are concerned, because they have done the recruitment process in contravention of the rule. So no estoppel will work against me, my lord. And moreover, my lord, I have relied one judgment of the Honorable Supreme Court. If my lord will see page number 13. Paragraph 5.5, my lord.
Yes.
My lord, it says, it's Rajkumar and others versus Shaktiraj and others, my lord. It says, paragraph 16, it says that the entire procedure is also obviously illegal. It is true, as contended by Sri So-and-so, that this court in Madan So-and-so and others, the decisions referred therein, had held that a candidate having taken a chance to appear in an interview and having remained unsuccessful cannot turn round and challenge either the constitutions of the selection board or the method of selections as being illegal. He is stopped to question the correctness of the selection, but in this case, the government have committed glaring illegalities in the procedure to get the candidates for examinations under the 1955 rules. So also in the method of selections and exercise of the power in taking out from the purview of the board, and also conduct of the selections in accordance with the rules. Therefore, the principle of estoppel by conduct or acquiescence has no applications to the fact in this case. Thus, we consider that the procedure offered under the 1955 rules adopted by the government or the committee, as well as the actions taken by the government, are not correct in law. So when, my lord, they have done it in total violation of the contravention, my lord, then, my lord, I have even though I have not been successful, I have not been successful because of unfair procedure that has been adopted by the state as far as recruitment is concerned. As it may be, my lord, because of my failure, that I was unsuccessful, and they have done the entire recruitment process in contraventions of the rule, my lord. It will not bar me. The estoppel will not work because it is against the law, my lord. So therefore, my humble submissions, my lord, till the time, my lord, writ petitions as well as the writ appeal is pending, my lord, I may be protected. No post can be filled in, my lord.
Yes.
Please, Your Lordship. Your Lordship, these 7 petitioners are all working on the contract basis. They were working because they had worked for about a year or 18 months at the most, Your Lordship.
Yes.
Now, Your Lordship, our rule, we firmly stand by this rule, Your Lordship, which says that at 7.5, Your Lordship, my friend had taken Your Lordships to that for the appointment to any post in the grade 2 junior shall be made by direct recruitment. This was being made by direct recruitment after advertising, Your Lordship, on the result of the examination/interview. My friend, while reading this point, Your Lordship, he just read examination/interview. But there, Your Lordship may kindly note that there is a slash. That means there is an option given to the authorities that you can hold a written examination or have a personal interview only for the purpose.
Is it correct, Indu?
I believe.
This slash part, examination or interview.
Yes.
Even if it is provided, is it valid?
It is because there is a letter, Your Lordship, which says clearly that.
One second. Just
This one. We'll deal with it.
Sorry.
So, Your Lordship, the rule says that, Your Lordship, examination/interview. So, Your Lordship, in pursuance to that, Your Lordship, an advertisement dated 26 May 2025 was published, Your Lordship, whereby applications were invited online. And the last date of filing the application was as on 27th June 2025, Your Lordship. That means 1 month time was given. And for the post of different posts were there, and at number 1 of the advertisement, Animal Husbandry and Veterinary Officer and the Animal Husbandry and Veterinary Department, Your Lordship. So, Your Lordship, now, Your Lordship, I take Your Lordships to para 6 of the advertisement, which is at page 67, Your Lordship, which is under the heading Method of Selection. This is the advertisement, Your Lordship. Now, the final selection, recommendation of suitable candidates against the vacancies notified in this advertisement shall be made by the Commission through the following processes. 6.1 is for the post of Animal Husbandry and Veterinary Officer under the Animal Husbandry and Veterinary Department. The Commission will adopt recruitment through direct interview as informed by the Department, white letter number dated so-and-so, which clearly says that it will be done only by interview, Your Lordship. So, Your Lordship, this was already there, and after having seen all this advertisement, the parties, the writ petitioners, have participated in the selection procedure. Now they were saying that they were given to understand that they would be accommodated, but there is no such commitment given by the department, Your Lordship, that they are going to accommodate all these people, Your Lordship. Selection was made in a fair manner, Your Lordship, without any arbitrariness, or illegalness, or biasness, Your Lordship. Now, because they have failed in the, have not been successful in the selection procedure, Your Lordship, they have turned around and they are challenging both the advertisement and the rules. And they are saying that the department has failed to follow the rules, and what we have done is contrary to rules. But this is not the case, Your Lordship. As on 22nd 9/2025, when this case, writ petition was moved before the single bench, Your Lordship, the rule was not in our hand, Your Lordship, and what was produced by the writ petitioner was this copy, which was not illegible at all, Your Lordship.
We have read
But
out all the
nonetheless, Your
copies.
Lordship, the court was pleased, because we sought for time to seek instructions for 2 days. Court was pleased to give status quo, allow status quo for a period of 2 days, Your Lordship. So on the date when it was fixed, that was yesterday on 25/9, Your Lordship, the court, after seeing the rules and after hearing the parties, Your Lordship, was pleased, was satisfied that the rules have not been contravened, Your Lordship. That 7.5 has been followed, Your Lordship, and that there was fairness in the conduct of the selection procedure, Your Lordship, which is why, Your Lordship, the court was pleased to vacate the status quo order, Your Lordship, and allow us to file the affidavit, Your Lordship. So this is at the initial stage only, Your Lordship. We are to file the affidavit, and Your Lordship, the other 51 candidates who have been successful in this selection procedure have not been made a party, Your Lordship. Now, Your Lordship, their prayer is that their results, their appointment order should not be issued. How can that be, Your Lordship? How can the fate of 51 people be held in suspension, Your Lordship, till this matter is over? At least they ought to have been made party and given an opportunity, Your Lordship. So my humble prayer is that, Your Lordship, the writ appeal is premature, Your Lordship. Status quo order should be discontinued only, Your Lordship, and we should be allowed to file an affidavit and fight the case.
Yes.
There's no infirmity in the order dated 25/9, Your Lordship.
Please, let's I appear on behalf of the MPSC. Before we embark on this entire exercise, I'd first like to take your lordships to the pleadings of the parties before the writ court, because it is at the very preliminary stage. As I draw your lordship's kind attention to the prayer in the writ petition, which my lords would find at page 37 of this memo of appeal.
Page 37. Yes.
My lords have page 37.
Yes.
My lords, may I just please pray? In the circumstances stated here and above, Honorable Court may be pleased to issue rule calling upon the respondents to show cause as to why the advertisement, my lords may kindly take note, the advertisement, bearing advertisement dated 26th May 2025, issued by MPSC along with the result published on so-and-so, and the governor should not be quashed and set aside. So, my lords, I fundamentally pause here to ask myself a question. That, my lords, now that I have not qualified in a certain examination, I not only want the results to go, my lords, I want the advertisement itself to go. Whereas it is my pleaded case and my case, my lords, that I was eligible and I have applied and sat for that very examination. That, my lords, would be clear from paragraph 4. My lords may kindly...
Again, same thing you are saying.
My lords, I am not on... I am on... Since my learned friend has urged the issue of estoppel in law, my lords, I am just coming to estoppel in law. My friend has raised the issue of estoppel in law. My lords, may kindly have a look at paragraph 4 and 5 for a second. At page 33, my lords. My lords, para 4, if my lords kindly have a look.
Yes.
That the petitioners having the requisite qualification has applied for the said post.
Yes.
Under that advertisement. So, my lords, if the advertisement itself is flawed, and now it is being urged that it is dehorse the rules. If it is dehorse the rules, my lords, why did I apply against it in the first place? I cannot, my lords, after having taken a bath in the Ganges, get up and say that no, I decided not to get wet. I voluntarily chose. Had the result been in favor of my learned friend, my lords, whether this question of it being vitiated by law being urged, simply because it suited me. And the dates would bear me out, my lords. My lords may kindly have a look at the date on which the my lords, advertisement was made. The advertisement, my lords, is made on the 26th of June 26th of May 2025. Now at 6.1, which my learned friend was, my lords, repeatedly harping, at page 67, my lords may kindly have a look. Holiness has woken up after I have been declared unsuccessful. Before that, I was very happy to be unholy. 6.1, my lords, may kindly have a look. For the post of animal husbandry and veterinary, my lords, 6.1, my lords have it.
Yes.
For the post of animal husbandry veterinary officer under the Animal Husbandry and Veterinary Department, the Commission will adopt recruitment through direct interview as informed by the department by letter dated 29/4/2025. I choose to come before this honorable court now, my lord, saying that the entire process is vitiated because I'm unsuccessful. But when this advertisement came, my lords, there was no questions asked. I was very happy to meet just the interview board and get a selection. So, my lords, what I'm trying to harp at is what my learned friend is.
No, this was part of the advertisement.
Yes, my lord, this is the advertisement. It is the advertisement itself I'm reading out. This read in conjunction with paragraph 4 and 5, this advertisement comes, it says interview under directions of the department by letter dated so and so, my lords, I very happily apply. When I don't become successful, my lords, I suddenly become wise, I become holy, I decide, no, this is all vitiated, it could not be like that. Question is, my lords, therefore, whether the question of estoppel of law will apply. If I have to invoke the law, my lords, I have to invoke the law at the first stage. The advertisement could have been challenged at that stage. No, it is incorrect. It is illegal. It could not be done like that. It has to be by written examination and interview, which my learned friend is urging now. But having taken my chance there, then coming before this honorable court, my lords, in my humble submission, it is not a question of estoppel in law, it would be an estoppel by conduct. Law will come to the aid of any person, my lords, who is agile enough to raise it at the first instance. After I take an opportunity of the lacuna in the law, I am very happy if I am successful. If I am unsuccessful, my lords, suddenly I decide and I wake up, no, the rules have not been followed, that may not be correct. That's the first part. And so far as, my lords, we are at the stage where, your lordships, the learned single judge has simply not continued with the order of status quo. The first order was very clear, my lords. It says that instructions till then status quo to be maintained. A prima facie view has now been taken, my lords, that it is examination stroke interview. Hence, interview was permitted. No interim orders to be continued. Affidavits to be filed. And, my lords, of course, if they succeed, as I pointed out before your lordships, my lords, the advertisement itself will have to go. So also the result. The question, therefore, my lords, at this stage before this honorable court, at this point would be whether, my lords, the petitioners are entitled to any kind of interim protection as against a person, my lords, who has gone through the regular course and been successful in an interview. My humble submission will be, it will not be. If they are successful, my lords, the advertisement will go, the select list will go. The other part is, my lords, if I may draw your lordship's attention to the prayer in the appeal. Prayer B, my lords, 6.2 at page 16.
16.
No, it's page 16 is the prayer.
Yes.
Well, let's give direction to the respondents to not give any appointment to candidates whose names are reflected in the result published by MPSC with notification dated so and so. Well, let's that prayer, whether it can be considered by this honorable court at this stage. Because, my lords, the people against whom they are seeking an injunction are not made parties before your lordships.
Yes.
The lordships are not going to pass some interim order against somebody who is not before my lords. So, if, my lord, somebody's appointment is to be blocked, he has to be necessarily been made a party before this honorable court. What I'm only submitting is, my lords, it's not that the case of the writ petition has been thrown out. Although we are arguing on merits at this stage, my lords, may not be necessary. We will file our affidavits. The matter will be examined by the learned single judge. And at some stage, my lords, if they are able to make out a case that it is indeed examination stroke interview, as my learned friend is contending, as against us, my lords, where we say it is,
If there is a slash provided in between the word,
my lord.
does it mean either or?
My lords, the interpretation given by the department to us is that it is interview. My lords, I cannot improve on what has already been there. Your lordships are very correct, my lords. The law is where it stands. But I am only saying this, my lords, that at this stage, whether, my lords, somebody who is successful in an examination, somebody who is not before your lordships, whether they can be made parties, whether an injunction can be granted against them. My humble submission is, my lord, the law does not support that.
Why have you not made them parties, Mr. Smith?
My lord, first of all, my lord,
in the writ you have not.
I will require addresses for all those 51 people, my lord. We are filing RTI for that, and moreover, there are so many judgments of the Honorable Supreme Court which says that it is not necessary that all those people who are result of a irregular process, they are not necessary to make them a party. It is not necessary to make them a party.
At this point of time,
my lord,
the court has not decided that the process is irregular. So
my lord,
you have to prima facie take it.
Yes.
See, that the interview has been conducted, they have been successful, and they are on the verge of being appointed.
My lord.
For which, you see, if any order is passed, I mean, that is well settled. It will affect them.
My lord.
For which they have to be heard.
Yes.
Principle of natural justice, so on and so forth comes.
My lord, we can make them party, and we are trying to get the address, all details about all those 51 people, my lord. So it will require some time. In the meantime, if the appointment is made, my lord, there will be no point for this pursuing with these cases, my lord. With the
not to address, there is a manner how service is to be effected. That is also provided by the apex law.
So we can implement all those 51 people, my lord.
It's not that you have to wait for the address.
My lord, we're trying actually, my lord, to get the address.
Address is not needed.
Yes, we can get it done.
Well,
you just have to record the name. The names are there, isn't it?
Yes, the names are there, my lord.
Lordships have indicated,
my lord. we can do that, my lord. My lord
may notified, but anyway,
my lord may kindly give us.
Only question I ask myself is whether the matter will be rendered infructuous if appointment orders are issued. In view of the prayer made by them,
it will create more chaos, my lord.
If I can just finish, please, just give a second. In my humble submission, my lords, it would not really affect the process. If they ultimately succeed, it is not only, my lords, his prayer is not only for setting aside the select list. His prayer is also for setting aside the advertisement. If advertisement goes, everything goes. So I don't think there is any question of prejudice being caused, my lords. The balance of equities was not in my learned friend's favor. The equities would be in favor of the people who have actually, my lords, gone through the examination along with the friends of my learned friend is representing, and, my lords, then come successful. If subsequently they succeed in the writ petition, my lords, it will go. The process itself will go. My lord. So whether it needs any, what my learned friend is, heaven will not fall, my lords, if appointment orders are issued.
My lord, this is the submission made by the MPSC, who is creation of the constitution, my lord, who is to maintain the fairness in the recruitment process. And moreover, my lord, what kind of fairness can be maintained in a personal interview, my lord, can have a guess about it, my lord. And when it is their own decision, my lord, own order, which says they will adopt the written examination / interview.
You're going through the same thing. So, you've heard the parties will pass the order.
My lord, oblige.
I'll oblige.
I am.